This is COM 330. We're looking at new tech law, and we're starting this part by looking at internet libel. Now, there are two difficulties in assessing internet libel. The first is the difficulty in assessing the size of the audience. It's difficult to assess the damage, the level of the damage, because you don't know how big the audience is. It could have been shared and spread beyond what you actually know. So if you're trying to find out how much damage could have been done to a person's reputation, that is difficult to say. The second is that ownership is sometimes difficult to assess, especially if it's from another country. It's somewhat anonymous. Now, they can trace it to a server, but some people can also use different tools to make that anonymous, and using overseas websites and things like that. So it can be difficult to do that, especially if you don't have a subpoena. You have to go to court, get subpoena, find out from the server who actually owns a email address, and find out what is who that person is, what's going on. Here's an example of a case that actually happened in Chicago. It was the Horizon Realty Company, and they sued for $50,000 for a person who had stayed in one of their apartments and tweeted about it. Now, here was the exact tweet. I'll read it. The exact tweet she wrote says, who says sleeping in a moldy apartment is bad for you? Sarcasm. Horizon thinks it's okay. So Horizon Realty Company in Chicago sued that person. In fact, if you Google Horizon Realty in Chicago, they are still there. They sued the tweeter for $50,000. Now, interestingly enough, the person who tweeted only had 20 followers, and the judge still allowed it to go forward, which is interesting because that's a pretty low threshold of people that it would have affected. So it went forward, and finally the judge said that the tweet was too vague. It was too vague to have caused a problem, and therefore the case was dismissed. But not because she only had 20 followers. So that's an interesting piece to that. Even though the whole case didn't come to fruition, didn't go through the entire process. Now let's take a look at copyright. And two parts concern us. The first is linking to another site. Are you allowed to do that? In the past, people have sued and said you can't do that, and there have been court cases on that. The way the law is now, yes, you can link to a legal site. If there's a site that is promoting something illegal in the United States, then that would be illegal. For instance, if it was a state that where marijuana is not allowed, a site that linked to that could be considered an illegal site. That could be considered a problem. But generally, if you're linking to a site, it's considered okay. That wasn't the case a number of years ago. But the first point about that is that it does not copy the material specifically, and so there's no specific copying, even though it's taking the person to that material. And the second is that it may actually drive traffic to the original site, and so it can actually help the person who is being linked to. Now, the second question is copying material directly allowed? And the answer there is no. Newspapers have sued and won in regard to that, people who have copied their material directly. And the idea on that is the difference between linking is that copying robs the originator, the provider of both advertising and money from subscriptions and other things. And so it is actually taking away from them, where linking is not considered to take away from the original poster. So those are two interesting aspects of copyright. Now let's take a look at music. And one of the big things that affects music on the internet is the Digital Copyright Millennium Act of 1998. Very important. It said basically that music on the internet is subject to licensing fees. Now, it's kind of bizarre to think that if you had music and you played it over the radio, you have to pay the licenser. It's usually ASCAP or BMI, but you have to pay the licensor for that, and the licensee. And but for a long time, I remember people would start internet radio stations, and so they didn't have to have all this equipment, but they also didn't have to pay for music fees, and that was interesting. Some radio stations also began to have online followings, but they didn't have to pay for the music every time somebody aired a song. They didn't have to pay royalties to that person on the internet, or they weren't. And so the Digital Millennium Copyright Millennium, not Millennial, Act was the thing that really changed that. And it's the reason that if you put some music now on YouTube, sometimes that will get removed. Sometimes there are cases where they do allow it, but sometimes somebody will say, I own the copyright to that, and have that removed. So that is the state of where music is at this time. Let's take a look at internet privacy, and this is kind of interesting because last week, just a couple of days ago, in fact, not even a week ago, Zoom was put under investigation for privacy violations, and the Zoom that most of us have been using in the last week or 2 weeks. And I'm personally, I've had a lot of video conferences, and video conferences are great, but we've had professors, and probably you as well, have probably had quite a few. I'm really missing in-person classes and conversations about now. But Zoom is under investigation for violating a privacy agreement with its users and sharing information they hadn't agreed to share with Facebook. And so it'll be interesting to see how that turns out. So internet privacy. It has a low level of protection, oddly enough. In fact, if you go to the bank or if you go shopping in real life, now if you go today, you'd have to wear a mask. But if you did go shopping, you would actually have more privacy protection doing that than if you shop on the internet. Maybe you're like me and using Instacart to get your groceries, there's less protection on that than if you actually go to a bank or a grocery store online. We're going to stop right there. We'll continue on our next video.